that you're able to join today our USIBC webinar on trade secrets protection in India. As you may know, we have a wonderful knowledge partner on IPR issues with Shardul Amarchan and Mangdalias. As you may know, Sam and Company, they're one of the oldest and largest law firms in India, and we've been very pleased to work with them on intellectual property issues. The idea is every quarter we're going to bring forward expertise and talk through various important issues around IPR. We encourage our members to join the conversation. We also will ask if you have any topics you'd like us to raise in the future, please feel free. We will record this session and make it available. We will also share the slides and be more than happy to connect you to our knowledge experts at Sam & Co. With that, Apurva, would you like to give an introduction and then we'll hand it over to JV?
Sure. Hi, good evening, everyone. I'm Apurva. I am a partner with the IP practice of Shardul Amarchan Mangaldas. I primarily handle contentious IP matters, mostly on the patent litigation side, and also the commercial transactions which are driven by intellectual property. That's just a brief about my practice. Today, we're going to speak a little bit about trade secret protection in India, but I'll let Abhay give a brief as he's going to start the presentation.
Thanks, Apurva. Hello, good evening, everyone. I'm JV Abhay. I'm partner with the IP practice of Shardul Amarchan. I handle trademark, copyright, and design issues, primarily enforcement, but I also keep an eye on the prosecution side of the practice as well. A very interesting topic today, protection of trade secrets in India. This has been something which has been of very high interest to everyone. So while trade secrets are protected in many countries of the world under statutes, for example, in the US, you have the Uniform Trade Secrets Act, the Defend Trade Secrets Act, etc. India does not have a specific legislation which provides for protection of trade secrets. India did make some previous references to protecting trade secrets under the draft National Innovation Bill, the National IP Rights Policy, and in the report by the Parliamentary Standing Committee in 2021, but nothing substantive happened after 2021. The recent development is that the Law Commission of India in its report has requested the government to consider a law on trade secrets. It has actually given a draft of the Trade Secrets Bill to the government for consideration. Now, this new law is being looked at by the Law Commission on primarily the following grounds: that they wanted to create an environment or an ecosystem where transfer of technology and issues emerging out of use of AI are dealt with properly. The present system, according to the Law Commission, is quite fragmented and difficult to navigate, and that a specific legislation on trade secrets would bring certainty to law. So with this, I think this is the brief background, and we are going to talk about the bill as well and what trade secrets are all about, how they are protected in India, and in what circumstances can an individual or a company look at trade secret protection. So now the definition of trade secrets as per the TRIPS agreement, even though India had in fact taken a stand against inclusion of trade secrets within the provision of the TRIPS, because according to India, trade secrets strictly do not fall within the ambit of IP. Nevertheless, Under the TRIPS agreement, Article 39(2) provides for a definition. It says natural and legal persons shall have the possibility of preventing information lawfully within their control from being disclosed to, acquired by, or used by others without their consent in a manner contrary to honest commercial practices, so long as such information. I stop here because the first part is important, because it can be divided into three parts. Firstly, that there has to be information which is a secret, which is not readily accessible to persons within the circles that normally deal with such information. Secondly, it has to have a commercial value. And third, that the holder of the information has to have taken reasonable steps within his control to protect such information from going to the public or being publicly disclosed. Now, the second is from disclosure or acquisition or use by others without consent. So there is an aspect of consent not having been taken from the holder of the information. And thirdly, that the disclosure or use should be contrary to honest commercial practices. That means that the use should be such which should be not honest and should in a manner affect the rights of the holder of the information. Now coming to what exactly the information should be. It should be a secret in the sense that it is not as a body or in the precise configuration and assembly of Apurva, can you just go back to the slide, please? And assembly of its components generally known among or readily accessible to persons within the circles that normally deal with the kind of information in question, has commercial value since it is a secret, and has been subject to reasonable steps. So these are the three things that I discussed just now when I talked about what amounts to or what constitutes trade secrets under the TRIPS agreement. So the other definitions have been um, which have been relied upon by courts of trade secrets are that a trade secret is a formula, process, device, or other business information that is kept confidential to maintain an advantage over competitors. The information includes a formula, pattern, compilation, program, device, and such like. Which derives independent economic value, actual or potential, from not being generally known or readily ascertainable by others, who can obtain economic value from its disclosure or use, and that is subject of reasonable efforts under the circumstances. So basically, even these definitions, both the definitions in Tata Motors versus State of Bengal and American Express versus Priyapuri, emphasize on the three tenets of what a trade secret ought to contain, which is first, information, second, which has not been disclosed, and reasonable efforts have been made by the holder of the information to keep it as a secret, and that it has commercial value. So these are three things which have been emphasized by courts as well. Um, for example, trade secrets can include formulas. Say, for example, the formula of Coca-Cola, for example, the Kentucky Fried Chicken, the WD-40, which is being used as an anti-rust. All these are examples of trade secrets which have not been revealed to the public. In fact, the secret of the Coca-Cola, uh, the drink, is in a vault in Atlanta. So, and it has substantial commercial value to the company as such. Um, and generally, what is seen is, say, for example, in the American Express versus Priyapuri case, client lists, for example, can also form a part of trade secrets and confidential information. I will explain that there is a slight difference between trade secrets and confidential information. Even though courts in India have used the terms interchangeably, there is a slight difference. Say, for example, as I said, in American Express versus Priya Puri, client lists, client databases, price lists, etc., do constitute confidential information. Um, Now, the difference between what a trade secret is and what a confidential information is that trade secrets are both are distinct, as I said. So confidential information comprises trade secrets, highly confidential information, and less confidential information. So confidential information is a broader term which includes trade secrets, even though, as I said, Indian courts have used the terms interchangeably. Um, Trade secrets in India are protected under equity and common law principles of breach of confidence. Um, the draft protection of trade secrets bill 2024, which we will be discussing later on in the presentation, is an attempt to bring in legislative protection to trade secrets. Um, Trade secrets and confidential information both fall within the purview of commercial disputes, and this has also been recognized under this draft trade secrets bill. Courts have interpreted provisions of statutes for protecting trade secrets, but limited to statutory language and the import of foreign precedents. So there is a lot of foreign precedents which have been relied upon by courts while deciding issues of trade secrets and confidential information. I will refer to some of those precedents in the subsequent slides. Um, Now,
Can
as
I
I
just
said,
jump in here? And I
yeah,
just
sure.
want to sort of make this real because trade secrets can be sort of complex, right? So would a sale, a few ideas are sales strategies, business processes that might be used in outsourcing, information in proposals, particularly technical. I see some digital companies that might be testing equipment. Are all those sorts of things, are there elements or pieces of that might be a trade secret? Can you just kind of elucidate using some, real examples of what, is covered, what's not, and so on? I think it would just be helpful to have that understanding before we apply it to
Sure.
the legal standard.
Sure, thanks. So, as I said, trade secrets would include anything which has commercial value, which has not been disclosed to the public, and steps have been taken to protect it by the holder. Say, for example, I gave three examples, right, of trade secrets. One is the formula of Coca-Cola, the Kentucky Fried Chicken recipe, and the WD-40 formula, which is the anti-rust solution which is used. So all these are of commercial value, held by the holder, not disclosed to the public. In fact, uh, specific steps have been taken by the holders to keep these um, as as secretive as possible. In terms
So
of
would like business
in
processing engineering, like a company's looking about how they might service a company and there's a certain process that's overlaid with technology, would that be included?
so so if that process is something which has substantial commercial value and which cannot be ascertained by just looking at generally available data in the public domain, you may kind of attribute that to be a trade secret or a confidential information.
Okay.
Especially as I said, say for example, in the case law that I just cited, American Express, what was involved was client lists.
Mhm.
Now, an argument can be made that the phone numbers or the names of clients can be publicly available. Right? And that is one of the defenses which was taken. But in that, an ex parte injunction was granted by the court.
Thank you.
So now moving on, the protection to trade secrets in India is under civil law and criminal law. Um Under civil law, you have the Indian Contract Act and you have the Information Technology Act. And under the criminal law, you have the Indian Penal Code and the Official Secrets Act. The Official Secrets Act may not apply to corporations as such. It is primarily something to do with government information, or maybe to do with corporations which deal with the defense sector primarily. I will be dealing with the civil law aspects, and Apurva will be dealing with the rest of the aspects. Now, protection of trade secrets under civil law. Um, what has to be demonstrated? What has to be demonstrated is, and as I said, the very definition kind of includes all these three tenets, that the information is used, or the trade secret is used in a manner contrary to honest commercial practices and has been acquired directly or indirectly from the right holder, causing loss to the right holder or gaining competitive advantage by the person company which has misappropriated the trade secret, and the owner has taken reasonable steps to maintain it as a secret. Again, the same tenets as have been laid down in the definition, the TRIPS agreement. Um, Now, under civil law, it is protected to a limited extent under the law of contract. Um, Now, the most common contracts that you see are employment contracts with employees, contracts between companies, and there may also be a situation when there is no underlying contractual obligation. I will be dealing with all these three situations in the presentation. First would be an employment contract with an employee. There can be a confidentiality and non-compete covenant. Then there can be an implied duty of confidence. Uh, this increases with the access rights and seniority. The higher the access and the higher the seniority, the higher is the implied duty of confidence. Now, there have been definitions which have been laid down by courts, for example, by the High Court of Calcutta in Fairfest Media versus LTE Group PLC, that the essence of this branch of law, whatever the origin it may be, is that a person who has obtained information in confidence is not allowed to use it as a springboard for activities detrimental to the person who made the confidential communication. So, again, the information should have been obtained in a manner contrary to honest practices. It should affect the holder in the sense that the right of the holder may get diluted, or there may be a commercial damage which may happen to the holder. Basically, that a detriment is caused to the holder of the confidential information. Uh, Again, when we talk about confidentiality and non-compete clauses, there is an inherent conflict with Section 27 of the Contract Act, because any agreement in restraint of lawful profession, trades, or business of any kind is void. And under Article 19(1)(g), the right to freedom of profession is there, which cannot be affected by such restrictions under an agreement. Now, the protection of trade secrets under civil law, again, this definition by the Bombay High Court in VM Deshpande and Arvind Mills Company Limited is very wide. It talks about the names of customers, all such things which are denominated objective knowledge. These may not be given away by a servant. They are his mister's property, and there is no rule of public interest which prevents a transfer of them against the mister's will being restrained. On the other hand, a man's aptitude, skill, dexterity, his manual or mental ability, all those things which in sound philosophical language are not objective but subjective, they may and they ought not to be relinquished by a servant. So a distinction was made on what can and what cannot be restrained as a trade secret. So uh, again, the distinction which was made was that a man's aptitude, his skill or dexterity, or his manual or mental ability, uh, which are not objective but subjective. They cannot be, if somebody takes that to us to another employee after leaving employment, they cannot be restrained from doing that. Um, this was observation was made by the High Court of Bombay by relying on Lord Shaw's judgment in Herbert Morris versus Saxelby. As I said, that a lot of foreign precedents have been relied upon by Indian courts while deciding such issues. Um, Now, specifically, I would like to discuss three or four issues, whether these confidentialities and non-compete covenants are contrary to Section 27 of the Contracts Act. Um, Now, these covenants can be of three types. One is non-compete, the second is non-solicit, and the third are confidentiality clauses. Now, the courts have made a slight distinction between the three clauses. In For non-compete, what the courts say is that restrictive covenants during the term of employment are enforceable, but those applicable post-employment are generally void. For non-solicit, what the courts say is they have applied the same principles as non-compete. Um, and for confidentiality clauses, courts have held that they are enforceable even post-employment. The principle which is generally followed in such cases is that no one can benefit or profit from wrongful use of information received in confidence. That's the basic principle which they apply for confidentiality clauses. Now, in terms of non-competes, non-solicit, and confidentiality clauses, these have generally been upheld by courts depending upon the facts of each case. An important consideration is the reasonableness of these covenants. The covenant should not be greater than necessary to protect the employer, nor unduly harsh or oppressive to the employee. A broad restrictive covenant is not favored, and this is what the Supreme Court has also held. And that's the next case law which I would refer to. Uh, This is the case law. This is the judgment of the Supreme Court in Niranjan Shankar Golikari versus Century Spinning, um, where they deal specifically with this question. They say that negative covenants operative during the period of the contract of employment, when the employee is bound to serve his employer exclusively, are generally not regarded as restraint of trade and therefore do not fall under Section 27 of the Contract Act. A negative covenant, that is, the employee would not engage himself in a trade or business or would not get himself employed by any other master for whom he would perform similar or substantially similar duties, is not therefore a restraint of trade unless the contract, as aforesaid, is unconscionable or excessively harsh or unreasonable or one-sided. So the bottom line is that these covenants uh, do not fall foul of Section 27 of the Contract Act, but they cannot, of course, be excessively harsh or unreasonable or one-sided. Now, in contracts between companies, which is, for example, a franchise and a partnership agreement, courts have taken a less constrained view and they have injuncted the defendants from revealing the trade secrets or using the confidential information. And they have found that these restrictive clauses should not be read as a detriment to enforcement of rights of the right holder. Um, these covenants have been viewed as necessary and facilitating the distribution of the goods and not as being a restraint of trade. The aspect of unfair competition and dealings have been considered by the courts even in absence of a contract. And this is very important that even if there is no contract, if the information is confidential, courts have restrained the defendants from revealing such trade secrets or confidential information, because it really does not matter whether there was a formal contract or not. General rules of equity and breach of confidence apply in such cases. Uh, so in absence of a contract, it's very important that we had the first case of Saltman Engineering, uh, which is a foreign precedent, which was where there was no contract, and what had happened was was that engineering drawings had been given to the defendants, and the defendants had shared it with the public or with a third party, and there was an injunction which was granted against the defendants. This precedent was followed by the Delhi High Court in John Richard Brady versus Chemical Equipment. Similar facts of the case where technical information know-how was shared with a third party. The court held that even though there is no underlying contract, an injunction ought to be granted and the defendants ought to be restrained from disclosing such information. Now, in an action based on breach of confidence, which I just discussed, what does the right holder have to show? The right holder has to clearly identify the information which he relies upon, show that it was handed over in circumstances of confidence, show that it was information that had to be treated as confidential, and show that it was used or threatened to be used without consent. Now, these tenets have been laid down by the High Court of Bombay in Z Telefilms versus Sundial Communications. This was a case which pertained to copyright infringement and protection of confidential information pertaining to a work titled Krish Kanhaiya. Obviously, it related to a work which was or could have been used with respect to movies. Now, to just sum up as to what the civil law provides in India, it provides that while an employer cannot bar a formal employee from using the skill and knowledge acquired during employment, he can definitely protect the holder can definitely protect the trade secrets or customers from the influence of the former employee. So, to sum it up, this is what even the courts have held, and that is what the present situation in India is with respect to trade secrets and confidential information. There are certain protections which are provided under criminal law as well, which Apurva will deal with in the next part of the presentation.
You. Do we have any questions that we have from our members on civil versus criminal? I mean, one of the questions that I have is why would something be civil and not criminal? I'm sure you'll get to that, but is there any easy test that sort of directs it in one direction or the other?
So, look, it may have elements of both, and we leave it up to generally the right holder to enforce it either by way of a civil action or a criminal action, because the aspect of dishonesty or malafide is always involved when we talk about trade secrets or confidential information. Uh, Generally, what we suggest is that the civil law process is much easier. You go to the court and get orders of injunction or appointment of commissioners, and you can ask the commissioners to collate evidence of the information having been shared. whereas going to the police, coordinating with the police and getting the criminal raids done may be something which may take time and effort. So, in an ideal situation, we generally suggest that the civil law approach be taken.
Right. Thank you. So Brian Daigle has, I think, a really great question. I'm just going to read it on non-competes. How is it decided if that non-compete agreement is one-sided? I mean, almost by definition, it's favoring the company over the employee. So is there some test or some determination between what might be considered one-sided?
So, generally, there is no test which has been laid down as such, but a reading of the agreement itself, if there is something which is excessive in the sense that post employment, if there is, say, for example, a restriction on someone not being able to do work in that particular sector altogether,
Mm-hmm.
that may be seen as excessive.
So
Say,
there
for
would be some
example,
discretionary, the judge would have some discretion in
that's
what that
right. That's right.
one-sided
Because
might look like.
because it would depend upon reading of the particular contract or the particular clause in the contract, and it would differ from uh, case to case.
Okay, thank you. Any other final questions before we move on? Okay. Purva, hand that back over to you, ma'am.
Okay, thank you so much. So moving on, now that we have spoken a little bit about what are the civil remedies which are available, there are also, I mean, even in the absence of specific legislation to address trade secret violation, the existing penal code in respect and the existing criminal legislations have come to the aid of right holders in the past. And I would like to talk about a few provisions which have been helpful in bringing a claim of violation of trade secret and the applicability of the provisions. The first one, of course, is theft. Some of the key ingredients of theft that would have to be demonstrated is uh, that the movable property has been dishonestly taken away from the possession of the owner without his consent. Of course, this is applicable to situations where, let's say, an ex-employee were to carry any material with him, either in physical form or in digital form. The ingredients of theft would be said to have been met. Um, this is actionable by imprisonment of up to 3 years. Similarly, there's another provision which is dishonest misappropriation of property. Here again, and the distinction between dishonest misappropriation of property and theft is a very slight one, which is that there is often times that it's possible that someone may have carried away material, an ex-employee may have carried away material without realizing that there is material which has been carried away. However, upon realizing, if that information or material is misappropriated or converted for his own benefit, let's say for a subsequent employer or for any personal gain, then such misappropriation would be said to be dishonest misappropriation of property. This again is applicable to movable property. And just a little background on this is that there's a lot of judicial precedent in India to demonstrate that intellectual property is movable property. So intellectual property does get covered by these provisions. Again, for dishonest misappropriation of property, uh, the punishment is 2 years of imprisonment or fine or both. Similarly, criminal breach of trust. Again, this is in scenarios where the elements that one would have to demonstrate is that the person who has committed this crime was entrusted or exercised a certain, was entrusted with the property in concern, and using this position of trust which was placed on the individual, he or she has misappropriated or converted such property for his own personal benefit. and in doing so has made any either dishonest use of the property or has disposed of the property in a certain manner. Also, if there has been a violation of a direction of law, then criminal breach of trust provisions would apply. Or if there's a violation of expressed contract term as well, you could apply criminal breach of trust. Again, here its imprisonment is up to for a period of 3 years, or fine, or both. There is a similar provision in respect of public servants as well, but of course, this is not really applicable, and this is more specific to a person who is a public servant, but not really in a general corporate relationship with the employee. Here, because of the sensitivity of the position that the public servant enjoys, the imprisonment term is a larger term, which is a term of 10 years and fine. One of the last provisions I would like to talk about is cheating and dishonestly inducing delivery of property, which is section 420 of the CIPC, of the IPC, which talks about cheating and dishonestly causing wrongful gain. Here again, if, for example, the provision covers scenarios where if a person were to induce another person to deliver property or to do something in respect of a property or to dishonestly, with a dishonest intention or with an intention to deceive such a person, then again, there would be, this is also actionable. The imprisonment term for this is 7 years, along with fine or both. Some of the specific legislations, including the Information Technology Act, also make out for some criminal liability which arises out of certain actions. For example, under Section 43 of the Information Technology Act, there is penalty provided for in case where a computer system or a computer resource has been accessed unauthorizedly, or where any data has been extracted from it without the consent of the owner, or if such a computer system or resource has been contaminated by, let's say, a Trojan horse, backdoor, or any sort of virus, or if any act has been done which would deny access or disrupt any computer software, or steal, conceal, or destroy, or alter the source code which is there in the computer system or the network. All of these activities would also be actionable under our criminal system. And um, the provisions is only to protect digitally stored information and its unauthorized use. Of course, because these are just criminal in nature, there is, the question of damages is something that can only get addressed if a civil action is also initiated simultaneously. One of the benefits that is there under the IT Act is that there is some allows for extra jurisdictional operation in certain instances. Under the IT Act, the Act provides for certain factors to be taken into consideration. For example, what is the amount of gain or unfair advantage which has been made, whether it's quantifiable, the amount of loss that has been caused to any person, and the repetitive nature of the defaulter. So, repetitive nature can have a higher penalty. Again, under Section 66, when the Act basically provides for the penalty, which says that if the acts are performed dishonestly or fraudulently, then an imprisonment of up to 3 years is what is actionable against the person liable, and then also a fine of up to 5 lakhs or both. There is a response, there are certain rules which empowers the computer emergency response team to investigate incidents of cybersecurity and include a breach of confidential breach which relates to breach of confidential data as well. There is another provision. There is a legislation which is the Official Secrets Act. This is more in relation to state secrets and other secrets which affect the sovereignty and integrity of the country. And so this was enacted primarily to protect official secrets. and its intention was to cover for any spying or espionage against the state. There is an imprisonment period of 3 years. However, this is not really applicable in situations where it's between a corporate and its employees or similar, or between two corporates. I'll now speak a little bit about.
Warba, I'm just going to jump in,
2020.
of course, and ask a question or two,
Sure.
if you don't mind, before we get
Yes.
into the report. So one of the things that we often see in India is people reluctant to go to the courts because of the time it takes. Are we seeing a lot of trade secret actions in the courts? And I was curious to see that hacking. I mean, that happens every day in the thousands, of course. Are we seeing a lot of activity here, or is this just sort of law that's out there if you really wanted to bring a case, or do you feel like the public and business at large, it's accessible to take on these cases?
So I'll say that a majority, at least on the civil side, the cases more are in relation to litigation between an ex-employee and the employer, more in the sense that it's information again, because the courts have been treating trade secret and confidential information they use it interchangeably, because of which primarily it is confidential information which may have been taken away by an ex-employee. That's the kind of litigation that we see a larger portion of when we consider this aspect. We've seen situations where, let's say, an employee moves on to another employer or sets up his own business and own, using, let's say, drawings or other confidential information of the employer. That's one situation. Of course, hacking and all of these things which are coming under the criminal, legislations and which have criminal consequences, these are dealt with. Not, I mean, they're not really reported like how civil judgments get reported. So these are more, you do have situations of hacking, you have situations where, um, you know, uh, there has been unauthorized access, and it's more, they don't really get reported as much because they get handled more between the law enforcement agency and the person who's bringing the complaint. So while there are such instances, I think the instances which are more prominently talked about and which get reported are actually the civil instances.
Thank you. Back to you.
Yeah. Thank you. So 2024 saw the Law Commission report, which talked primarily on trade secrets. And so the Law Commission prepared this report, which covered a large array of how trade secret protection is afforded in other jurisdictions, specifically in the US, in EU, Japan. Also, it talked about what the definition of trade secret is, how it must be broad to allow for judicial interpretation, because trade secret by its very nature it's difficult to peg it into a certain kind of a mold, for the reason that it's unique to the business of the entity claiming it to be a trade secret, and it's unique to its competitor. So something that has commercial value to one, to a company maybe in a certain line of business, may have absolutely no value to someone else in another line of business. However, because it has certain commercial value to this person, it does have that status of a trade secret. Therefore, the Law Commission report also talked about how the definition must be kept broad. It might maybe and only provide for broad guidelines in terms of how you would determine what something were a trade secret, instead of identifying what could or could not be trade secret. Again, the report did emphasize on the triple criteria which has been provided under the TRIPS, which is secrecy, commercial value, and reasonable steps, which is that the entity claiming for something to be a trade secret has maintained that secrecy, that information has certain commercial value, and that it has taken reasonable steps to prevent such information from becoming public. Of course, there are exceptions for for situations with a whistleblower. The report talks about manners of compulsory licensing or governmental use in a situation where there is a national emergency, and also talks about freedom to speech and expression and public interest. However, we'll address that a little bit when we talk a little more about about the draft bill, actually. The Law Commission report also talked about how the civil remedies which are available in respect of violation of trade secret should include injunctive relief, damages, rendition of accounts of profit, delivery up, destruction, etc. And also said that all the criminal provisions of the IPC or any subsequent legislation which may come to effect, because India right now is at the stage where, as of July 1st, the Indian Penal Code, the Criminal Procedure Code, and the Evidence Act are going to be replaced by 3 new legislations, which are modeled on its predecessor. But the idea of the Law Commission report was that any subsequent legislation which also has any criminal implication or identifies an act to be a criminal act, those should also be applicable. And now confidentiality clubs are something that historically came about because of standard essential patent litigations, and the Delhi High Court framed rules around it, saying in certain instances, if there had to be disclosure of certain information being confidential in nature, then there should be a confidentiality club which is set up. The parties to the club are required to, provide affidavits, stating that they would be maintaining secrecy in relation to the information that they're provided. So similarly, the Law Commission report talks about the merits of a confidentiality club, even in relation to disputes relating to violation of trade secret. This may also be stemming from the fact that there have historically been judgments which say that, or which require disclosure of the confidential information in a dispute in order to determine whether there has been a violation thereof. So, the sensitivity of it is that if a plaintiff were to bring a dispute of violation of its confidential information, to what extent would it have to make a disclosure of it uh, to the court? In what manner would it get documented? To what extent would the defendant have access to it? And under what terms does the defendant have access to it? And under what terms does the counsel of the defendant have access to it? Because at the end of the day, the idea of the litigation is only to curb a certain violation and not to basically put the trade secret in public domain, right? So, of course, establishment of confidentiality clubs is very relevant in this context. But then again, there's also that balance, saying the negative covenants of post-employment restraints must not be permitted, specifically in case of an employer-employee situation, where an employee who has acquired a certain skill set, who has been in a certain line of business, cannot be prevented from joining a competitor merely on the presumption that the employee has had access to certain trade secrets during the course of his employment. So there has to be that demonstration of a violation of any, let's say a contractual obligation, or any violation by the employee to the extent that he has acted in a manner which is contrary to honest commercial practices by moving to a subsequent employer, and not simply moving to a competitor organization as an employer. uh, it can't trigger a violation of a trade secret as such. um, of course. So just broadly, what the bill talks, some of the provisions in the draft bill, it defines trade secrets. It says it's a secret not generally known or readily accessible to relevant business circles. It derives commercial value from its secrecy, and it's subject to reasonable measures by its holder to maintain its secrecy. Certain features which are there in the bill are the whistleblower protection, public interest exception, compulsory licensing provision, and confidentiality club. It may be interesting to see how this draft bill evolves in relation to these provisions that have been, provided for at this stage. Um, Again, some of the remedies which are available is injunctive relief, compensation. So Similar to the Copyright Act, it says that you have an option for damages or the right holder has an option for damages or rendition for accounts of profit at the option of the plaintiff. So they can choose what is the kind of remedy that they're looking for. Of course, destruction of documents, materials, electronic goods, anything to prevent further dissemination of the stolen trade secret is something which are part of the remedies which are available to which are likely to be available to a right holder. This also emanates from previous positions taken by the judiciary in India, where it says that the remedies available to the owner of trade secrets is to obtain an injunction preventing the licensee from disclosing the trade secret, return of all confidential and proprietary information, and compensation for any loss. And Jay, just to your question that you asked earlier as to is there a benefit of civil over criminal? Or if people choose one over the other, I think because of the currency and the urgency with which you're trying to prevent a dissemination of trade secrets, the civil route is beneficial in that sense, because then you can get injunctive relief while the suit gets disposed. Whereas in criminal, if you were to take the criminal route, that's one remedy that you're sort of one remedy that's still lacking on the criminal side, that you may not get any injunctive relief while the investigation is ongoing, or there may be other such activities. So to prevent that immediate seizure of any further dissemination, given the digital era that we are in, I think that's where the civil remedy has a little more benefit than the criminal one. Of course, there are benefits to the criminal side as well. But yeah, I mean, for the dissemination is, I would say, the primary one. So as a conclusion, some of the challenges now, of course, while India has not had a legislation which is specific to trade secrets, the courts are not, I mean, trade secret is not a concept that's alien to the courts. They have in the past been very proactive, and I'm sure a lot of you may know already that the Delhi High Court and the Madras High Court now have an IP division which exclusively hears IP matters. So, they're far more well versed in terms of handling such issues. And we see them far more often now with the digital, usage of keeping everything in a digital format. So from an enforcement perspective, even with the lack of legislation, that enforcement is happening to some extent. However, there are certain challenges which are, faced. One is lack of awareness. Lack of awareness amongst both right holders, lack of awareness amongst employees, people who are regularly accessing these confidential information, their usage of it. A lot of it may not, it's not everything is with a malified intent. So that awareness is definitely something that people should be working towards, whether it is at an organizational level or otherwise. Similarly, there's a lack of standard of rights and liabilities, because there's this confusion which is there among the various stakeholders. Employees, now, if an employer is trying to, like, an employment agreement can have a really onerous non-compete clause, but to what extent is it enforceable? To what extent is it enforceable from preventing an employee in doing certain activities? Those are things that both stakeholders have to be aware of, because it also helps in your employment agreements to draft it in a fashion that it's going to get carry in court, rather than drafting an overtly onerous one which is likely to get struck down. Again, lack of quick redressal mechanisms and interim relief. This is something that we definitely feel on the criminal side. But having a specific legislation may give you that extra ability to, prevent for further dissemination, and a quicker redressal mechanism. There's also multiplicity of proceedings causing delay and ineffective prosecution. But that's, and a single redressal mechanism would address this issue. Again, chances of secrecy of information getting compromised. This is specifically because in the past, courts have applied that principle that if a defendant has to legitimately respond to a claim which is being brought against him, then he needs to be, then a full disclosure of what is that claim needs to be made. And to that extent, I think the plaintiff is also hesitant because this may result in actual dissemination of the trade secret in a much more public fashion than the plaintiff had envisaged. So to counter this, there are certain existing remedies, which is setting up of confidentiality club. However, if it gets that statutory backing, then that is something that's going to be really beneficial for right holders and for both parties, in fact, because it's not uncommon that there is that often a claim may arise in terms of breach of trade secret. However, there is legitimacy to the defense that is being brought up as well, and the defendant may also have some technical input or some development that they may have done at their own at their end, which they may be able to demonstrate by way of evidence, and all of this needs to be maintained in confidence, in confidence, because the right as important as the plaintiff's confidential information and trade secret is, oftentimes if that sort of a claim is brought against a competitor, then there are other motivations as well. So in order to protect the interests of both parties, confidentiality clubs are definitely a really good mechanism. There has been difficulty in past in securing and enforcing damages, because under the Indian system, any damage that is granted, it has to be actual damage, and the plaintiff carries the burden of proving such actual damages. So and it's not just securing that order of grant of damages. Subsequently, there also has to be, you need to file yet another petition for execution of the order in order to obtain those damages, which may include several steps such as attachment of the defendant's property, and it's only then when the damage is actually realized. So having a more streamlined approach to this may definitely be beneficial for the right holders. Also, the fines which are there under the criminal law are not really a deterrent at this point of time. I think the deterrent is the prison term, and oftentimes you will see, and it's entirely dependent on the facts of the case as to what is the, if or in such instances where fine is also provided for. So that's definitely something that can be addressed. Also, and in criminal law, if a criminal claim is to be brought, the burden that the plaintiff has to meet is far higher, while in a civil claim, he only has to demonstrate preponderance of probability, but in criminal, you would have to demonstrate beyond reasonable doubt. So that definitely is something that's a challenge that is being faced. Of course, I don't see that the threshold changing pursuant to this legislation, but that is definitely a challenge in enforcement when you weigh civil versus criminal. So these were just some thoughts that we had. I'm happy to address any questions or answer anything anyone may have.
Thank you. Purva, if you could stop screen sharing, we could go to some questions and answers. I want to thank you and JV. That was just a really superb background and primer. Hopefully we can share that with, share the presentation with members, and we'll connect you. My first question is, where do we go from here? The Law Commission has issued a report. There's a draft bill floating around. There's a new government. Kind of tell us how this may or may not play out.
So we are confident that this will play out well for protection of trade secrets, that we are going to have some kind of a legislation which protects it. But of course, there are several steps which are yet to be taken. First, it might be put up for stakeholder comments. And then whatever changes are required to be made will have to be made, and then ultimately this gets passed. So may not happen in the next 1 or 2 months, or the next 3-4 months, but the vision is there, and we are confident that this might just go through.
Right.
And of course, the inputs from the stakeholders will be very important, because that is something which will have to be looked at.
Right. Just help us out here. So the Law Commission, the bill has to be presented to Parliament through the Law Commission, or does it go through a ministerial process as well.
So it has to go through the ministerial process. I think the Law Commission is just just makes a recommendation that this legislation has to be there. Uh, Ultimately, it is with the government and looking at what kind of stakeholder involvement there is. Um, the government may just kind of decide to go ahead with the bill, and ultimately it takes the shape of a law or
Right.
a legislation.
Also, the bill is also likely to see, oftentimes, even if the Law Commission has made the recommendation, the bill is likely to see some sort of evolution when it actually gets placed before the parliament. So, right now we don't have any visibility on how that's going to look like, but yeah, that's something that's definitely possible.
Right. And the ministry we're talking about is Ministry of Law and Justice. Is that where it would go through?
That's right. Yeah.
Okay,
Yeah.
great. As expert practitioners, you've read through the report, and even if a layman did, they may not understand. Are there any pitfalls or things in the initial report that could generally be concerning, or is this just overall a really positive step, and we want it to become, roughly enacted as written?
So some challenges, it may, like I said, the bill I feel is still at a recommendation stage and it's likely to go through some changes. So it may be interesting to see how specifically the provisions on compulsory licensing get fleshed out, in the sense that what's the sort of mechanism that's proposed basis which compulsory licensing may even apply. Because historically, how we have seen compulsory license apply is, if there is a statutory right, then the grant of the statutory right is subject to certain provisions in the law, which is that you may be subject to compulsory license if you don't meet XYZ requirement. However, it would be interesting to see how they make this applicable to trade secret, where there isn't a statutory protection which is being sought, but a mechanism to seek a compulsory license in respect of it is being provided for. So that's, I think that it would be interesting to see how that evolves a little bit.
Okay, wonderful.
But overall, if you see, Jacob, I think the intent is there, and that is what matters, because post 2021, we did not see too much of movement on this front, the trade secret front. At least we have something in hand, at least what has been provided by the Law Commission. Of course, as Apurva said, a lot of things will have to be discussed with the stakeholders and with other agencies, and then kind of we will have a final version of the bill, which will, I hope, uh, kind of culminate into a formal legislation or an act.
Wonderful. Well, absent any final questions or comments, I want to thank you both for coming onto our platform. We hope for our members and guests that this was a useful conversation. As I said at the top of the hour, we plan to have a quarterly conversation on IPR. We're really excited to invite Salmon Company back for that. But if there's any suggestions of topics or issues that we should raise between here and now, please don't hesitate to reach out to us. Finally, we will make this recording and the slides available, and I'm happy to connect you with our experts. And once again, a third time, I want to thank Apurva and JV for your just incredible insight here, and really appreciate your time and appreciate it very much. And let me wish you a good evening in India, and for our members elsewhere, a good morning or afternoon. Thank you very much.
Thank you. Thank you.
Thank you so much.